Hello, this is Jonathan Mosley, former attorney, now retired, and I want to talk about some of the legal news that's just developed. Primarily, that Candace Owens has been sued now for her campaign about Charlie Kirk's assassination and statements about a great many number of people. I hope this is working. I still don't have the updated software because I've been busy fighting the left and things like that. But we the thing is that I'm going to get I've got getting together a whole software from Greg Penglis, who's pausing his radio show podcast. So here's the thing. We heard a few months ago that Candace Owens, and some people might ask, well, who's Candace Owens? Well, she kind of popped out of nowhere over the last few years, and and especially has been on a big campaign about Charlie Kirk's assassination, the head of Turning Point USA, and basically blaming everybody to an absurd extent. I think I've given my interpretation of it. She received a number of cease and desist letters from lawyers, from different people that she has talked about as being responsible, or just weird. It just doesn't feel right. She claims to have had a dream about who is responsible for Charlie Kirk's death. She I've talked about all kinds of strange reasons why she wants to blame people for Candace Owens for Charlie Kirk's death, and a number of those people filed one or more cease and desist letters. That's not a lawsuit. That's a preliminary step to a lawsuit in which a person wants to say, in a variety of contexts, it might be trademark infringement, contract infringement, having wild animals at your rented apartment that the landlord doesn't like, anything where somebody just says, if you, please stop. And it can hold people to a higher level of a higher standard, higher level of liability if they were warned but didn't do it. Kind of like, I don't know if this helps to go off on a tangent, but trespass is only actionable if it's either posted, you're not welcome, or someone is on your property and you tell them to leave. If someone comes on your property and you didn't tell them that it's private and you don't tell them to leave, I'm not saying this makes sense, but that's the law is you have to tell them to leave first. So in many many contexts, a cease and desist letter is just a step in the direction of saying, stop, you're not authorized to do this. What you said was a lie, don't do it. Now, there's a lot of details about a cease and desist letter, which I'm not going to probably waste a lot of time on today. But you may have heard in the news that there were cease and desist letters. That's not the lawsuit. Last couple of days, in the Middle District of Tennessee, BRIAN HARPOLE sued Candace Owens LLC, Limited Liability Corporation in Delaware, Georgetown Incorporated, which I've never heard of, and this is the first time I've heard. Not that I know of everything that exists, but this is the first time it's coming to my attention that there's another entity, and Mitchell Snow. And this has become a big controversy because everybody's wondering, why hasn't Eric Kirk sued? She should not be this nice. Turning Point USA is obviously being damaged. The intention of all this campaign of commentary by Candace Owens is to destroy, while pretending to have been Charlie Kirk's best friend, the entity that helped Trump get elected, especially organizing young people. The Democrats have always fantasized since the 1970s that they own the youth vote. Well, they don't. I mean, most conventional wisdom in Washington, D.C. and politics is wrong. It's stupid things that self-proclaimed experts tell each other, and it's some truth that is said over cocktails at a cocktail party in some political thing, and everybody like nods their head and thinks this is true. It's objectively false. It's never been proven true, but there are a lot of these things that are believed to be true in American politics in Washington, D.C. And one is that the Democrats fantasize that they have that one of their constituency is the young voters. The reality is that young voters don't vote. The most reliable voters are seniors. The older voters get, the more reliable they are to actually turn out and vote. Young voters may be very loud and opinionated, which has been said by philosophers through the ages. The excessive enthusiasm and arrogance and naivete of the young. So they talk a lot, but they don't do anything. They might go out and protest in public, hoping to impress and meet a chick to date. But if you ask them to actually do anything politically, nah, they're too busy to turn out and vote. But Turning Point USA actually did mobilize the young vote, especially, to a tremendous extent, and move that entire voting bloc from don't care, we'll hear myself yell and talk and try to impress people, but don't really care, over to the Trump column to actually turn out and vote. And the left correctly perceives Turning Point USA and associated and similar efforts to be a fatal threat to the Democrat Party. And their only chance of beating the Republicans is to try to recapture that young vote any way they can. So this is all about the destruction of Turning Point USA and efforts to get the young vote for Republicans. You may say, I don't care about Candace Owens, I don't care about Erica Kirk, I don't really care that much about Charlie Kirk. This is all a big, nasty food fight. I don't really care that much about it. But you have to understand the context that this is about the future. It is about a dishonest, lying, deceitful, disgusting attack on efforts to get this country on track in governance, to get to educate the young, especially the young, but others, but mainly the young, and to achieve the biggest win of just getting people to turn out and not vote at all. So the Candace Owens scam would be successful if it is just so disgusting and turns people's stomach and makes everybody nauseous, so they just don't vote. And then the reliable voting blocks for the Democrats will vote, and the Democrats will win in the midterms and in 2028 for president. So this is why you care. I should have labeled it that way to begin with. All right, so everybody's saying, why hasn't Turning Point USA followed up on its cease and desist letters? Why hasn't Erica Kirk sued? She's been accused of assassinating her husband, and in the most cruel and awful ways. And finally, somebody sued. This is why the social media, especially the defenders of Turning Point USA, and again, they're being one group of people who are blocking the attack on our country to try to turn our country over back to the left. Some of them know people in Turning Point USA, but mostly they would recognize this is an attack on all of us. We try to steal this country for communism and wackos and and Muslims and everything, and basically everything, everyone who stands against this country. Okay, so this is the first complaint, and it's created a lot of things. Candace Owens, again, about the software. When I get Greg Eglis to help me, I'll be able to put up her video. I'm just not set up quite that well right now. But the thing is that she's saying, "Oh, this is great. We can now get discovery." Because Candace is part of Candace Owens' many scams is to demand information that she has no right to demand. She says, "Tell me, where were you in this on such and such a date?" It's like, "It's none of your damn business. Who the hell are you? You're not part of the investigation. You're just some, you know, big mouth on the internet. Nobody cares what you think. Nobody cares what you want." And so she says people are guilty because she demands to know things that it's none of her damn business, and they don't answer because it's none of her damn business. And so now they're saying, well, so she's been daring people to sue her because she says she'll get discovered. Is that true? Is the Candace Owens scam going to make a major turn because she can now get discovery in court as part of these lawsuits? That's the most important thing that I want to address and educate you about today, having been an attorney for 26 years. And by the way, I'm not a practicing attorney now, but I have time on my hands to share that. I do not like these glasses. Anyway, so here's the thing. A lot of other details that would be useful for you to know that people are talking about. The wonderful Paramount Technical series of websites goes into a lot of it, and they make an effort to know a lot more about the law and important things than most commentators. But not having been lawyers, they're a little bit at a loss. So let's talk about what's going to happen. First of all, Candace Owens has been demanding information she has no right to demand. The proper answer is, and who are you? What? I mean, this is not like a Western movie where the sheriff deputizes the men of the town. Says, raise your right hand, you're now deputized in the posse. No, nobody, she's got nothing to do with anybody, anything. There's this huge crowd of people who didn't like Turning Point USA in the first place. And they all want to say, like, oh, Erica Kirk sounds weird. No, she does not. You sound weird, but she does not. They really are obviously lying. They're probably not even Americans. Remember, on Twitter and social media, when somebody says their name is John Smith, their real name may be Ahmed El Shabazz, IED, Al Scimitar, just because they pick a photograph of a Westerner and put up a name doesn't mean they're American. And so for whatever reason, they're all attacking and things like this, and I want to know, like, well, what makes Erica Kirk qualified to run Turning Point USA? None of your damn business. Do you support Turning Point USA? No, you don't. Do you agree with its goals? No, you don't. Did you donate to Turning Point USA? No, you didn't. What the hell business is it of yours? Who runs an organization that you have nothing to do with and don't even support? To hell with you. So there's all this attack on Erica Kirk because the goal. Why would, from the science of public relations and politics, to do what they're doing is really kind of dumb if they don't, unless they have another goal. Because if you take out Charlie Kirk with assassination from the left, and remember, there were posts up to 10 days beforehand saying something big is going to happen on September 10th. Charlie Kirk is not going to, they alluded to the fact that they knew at least 10 days before Charlie Kirk was shot on the left, that he was going to be gone. So Why would, if you were going to do that, the smart public relations move is to stay low, do it, and then say, "Oh, isn't that terrible? He's gone," and not draw attention to yourself attacking his widow. Attacking Charlie Kirk's widow is bad public relations for what they were trying to accomplish by destroying Charlie, by silencing him in politics. Unless they can't accomplish their goals without destroying her too. They want to destroy Turning Point USA. It wasn't about Charlie Kirk, and it's not about Erica Kirk. It's about taking an army off the field so the Democrats can cheat in the election, which is what they always do. They want to eliminate their competition. That's the only reason to both kill Charlie Kirk and smear Erica Kirk. I mean, you would want to come across as likable and sympathize with Erica Kirk. Oh, it's so terrible what happened to her. I mean, if you really want your message to go down and not to be resisted, they should be sympathetic to Erica Kirk, but they're not, because they're trying to swing the election, which affects you, whether you've ever been to a Turning Point USA event or you ever will or whatever. So anyway, so this is where we're at. So Candace Owens has been saying, "Oh, this is great. Somebody sue me because then I can get discovery." Discovery is a process in a lawsuit in court where you can use the power of the court, both standing rules that are always true and specific actions that you ask the judge to authorize. There are standard rules, and the judge can modify them, can add to them, and restrict them. Pretty much all the rules in a civil lawsuit are, unless the court orders otherwise. You have all these rules, say this is how it works in a civil lawsuit, unless the judge orders otherwise. And so you have all these rules, and then you can go and petition the judge for other actions. And we'll talk about a little bit about it. I'm fearful as I think about this is going to go long, but it really should. So you can add to the rules, change the rules, ask the judge for something specific, and make your best case that you get additional information as part of the lawsuit. And those are two different categories, but they're all part of what's called discovery, the discovery process. I'm afraid we have a lot of shorthands in the law that are usually not really very helpful. Anyway, so the thing is, why is Candace Owens taunting someone to sue? Well, it might be difficult for her to sue because it's none of her damn business. The legal term for that is she has no standing. It's none of her damn business. So how would she sue with something that she has nothing to do with? But in theory, instead of just taunting somebody to sue her, or by lying about them a lot, she might have sued herself. So found some way to do it, and it might have worked. But she wanted to be sued because then she can respond by asking for discovery questions. Now let me cover a little bit of context details here, and then get to the main event. This was filed in the United States District Court in the Middle District of Tennessee, the Nashville Division, which is mostly done well because it asserts, which I believe to be true, that the defendant, the main defendant, the lead defendant, Candace Owens, is a resident of Nashville, Tennessee. The complainant, the plaintiff, BRIAN HARPOLE, it resides, lives in Texas. So he went out of his home state to the state where Candace Owens lives to sue her there. Now that is probably, well, if it was just that by itself, that is the best way to do it, to make sure that Tennessee has jurisdiction. Jurisdiction can be a very messy problem. So they've done that right. Let me get the attorney, the name of the attorney. This is 68 pages down to the signature block. Um, Man, I really wish I was set up with the right software. I'm gonna have to work on that. I have other things to do, unfortunately. Its case number is 3:26 CV. CV is for civil dash 00556 in in the United District Court, the Middle District of Tennessee. And I'll put a link in the down description. But I'd like to do better than that. And The plaintiff is BRIAN HARPOLE, HARPOLE. And again, case number 3:26 CV 00556. And If you go to the federal website, it costs, and it ain't cheap. There are other services which publish newsworthy stuff. They don't publish everything, and even on a case they consider newsworthy, they don't publish all of the documents. But this is available, for example, on Scribd, SCRIBD. You can get a free trial, but they want your credit card. So if you don't pay attention, they'll start billing you. So I'm sure it's probably also available on courtlistener.com. They do a fabulous job when they decide to cover a case. So you don't have to pay Pacer to get a copy of this. And there will be ongoing developments, no doubt. So the lawyer did a good job on choosing where to sue Candace Owens. The lawyer is Matthew Serrelson, Esquire. Now, some people are commenting that, Zachary Stoner is from West Palm Beach, Florida. He is with the Dillon Law Group, which is Harmeet Dillon, who is one of our current top DOJ officials. Obviously, would have to recuse herself from any of the business of her law firm, which ain't easy. But obviously, Harmeet Dillon is not actually involved in this. But Interesting. So anyway, her law firm going on without her, not because she's I think associate, not assistant, but associate attorney general for civil rights at the Trump Department of Justice. Anyway, but then people say, oh well, he's not even licensed in Tennessee. Yes, you have to be licensed, but getting a local counsel is, I don't really like it that much, but it's rampant. The idea that you want to sue somebody in Tennessee and you're not licensed in Tennessee, you just find somebody local and say, hey, would you please sponsor me? It's called Pro Hoc Vice. And sure. Now, the rules are different in different states. Sometimes the local attorney has to sit in at every minute, read the pleadings, sign the pleadings. Other places they don't. I was Pro Hoc Vice in the Northern District, I believe, of Texas, and the rules were very convenient there. I had to go through the process, but then I didn't have to have local counsel show up and pay local counsel for every single thing. They've also got from Boca Raton, Florida, Contarino Roth, and the Tennessee lawyer is the Swafford law firm, Tara Swafford. So people are complaining like, oh, the guy's not licensed in Tennessee. No problem. Yes, it's some paperwork. Yes, it has to be done right. Yes, it has to be done carefully, but not a problem. So now the other thing though is that Candace Owens has Candace Owens LLC, an entity, a business entity, limited liability corporation. Now, the reason you do that is really to protect against liability. You put assets that are in the LLC in the company and try to make them untouchable from things that you do. That's having, like, Jonathan Mosley, myself, and then Jonathan Mosley um, Inc. Why would you do that? Because you want to kind of keep them separate. Here, it doesn't matter and it doesn't work, because everything that is at issue here is Candace Owens saying things out of her own mouth, on camera, willingly, without coercion, eager to say things out of her own mouth. So whether they sue Candace Owens LLC really doesn't matter, unless she stashed money there somehow, and they win, unless the lawyers are stupid. But presumably this would be hard. This is a hard case to lose. So they they win, and then they want to go after the money that is stashed in Candace Owens LLC. Maybe it would help. Now, like most of business, Candace Owens LLC is incorporated in Delaware. Now, I don't know. I'm not telling any secrets to say that they have the same lawyer. They probably have the same lawyer. It's not a conflict. It's not a conflict of interest, really. But their lawyer for the LLC is going to go in and say you don't have jurisdiction over this thing. We're in Tennessee. The LLC is in Delaware. How do you have jurisdiction over the things in Delaware? So this federal court might not be able to reach the LLC, but it doesn't matter, as I said. But the thing is that they there are several ways to have jurisdiction, and if the LLC participated in the action sued about, that would be an exception to that jurisdiction would exist under the long arm statute. But here they've sued in Tennessee because that's where Candace Owens lives, not because that's where. Well, no, I take it back, because apparently she broadcasts from her basement. She's got a studio set up there. So the actions involved are in Tennessee. Not just that she can be reached in Tennessee by a lawsuit, but she did everything that she did in Tennessee, or almost everything that I know. That's, I'm not on the case. I haven't studied every piece of paper, but I think that's just kind of the general guess, is that apparently she broadcasts. She might have broadcast from somewhere else on one occasion or whatever like that. I'm just saying I don't know, but I think that the Delaware LLC might be reached by the long arm jurisdiction because it was involved somehow in the actions in Tennessee that happened in Tennessee. So they might be able to get that. Then they're also suing Mitchell Snow, who's a resident of Washington State. Now, that may be a problem. Who's Mitchell Snow? Mitchell Snow is her source, about the only source she's had that's gone on the record, and said all these things about a meeting in Fort Huachuca. I'm sorry. This just sounds. If you really want to know what's going on here, go to, I think it's Hulu, is the main source of it. There's this dumb named TV series with Selena Gomez, and she plays a much more serious character than you know. And it's called Only Murders in the Building, which is a silly name, but it's a crime drama. It's just these neighbors in this big, huge apartment complex who get together and solve crimes. And they solve a crime, they get it to the police hate them, but have to admit they broke the case. So they decide, well, we're not going to stop, are we? And Selena Gomez's character says, well, I don't know if I want to do this. And so they finally said, well, okay, we're only going to do murders in the building. She's like, that's not going to come up very often. So that's where the name comes from. It's like, well, if there's another murder in our building, we'll do it, but we're not going to roam all over the New York City. So anyway, that's what this is about. This is all Fort Huachuca. Oh, sounds exotic, right? Sounds interesting. So bored housewives, what somebody called the wine, WINE women, who are just sitting home, drinking wine and have nothing to do, and so they want to participate in this ridiculous investigation. Um, it's really what's going on here. Right? They've got people who got nothing better to do but to so Fort Huachuca. Like, why Fort Huachuca? Because it sounds exotic. It sounds amazing. So Mitchell Snow basically accused Erica Kirk and BRIAN HARPOLE and others at Turning Point USA of plotting with the U.S. military to assassinate Charlie Kirk. As you said it so many times, so many different ways, that any clever wording is not going to work with Candace Owens, because you said it too many different ways and cumulatively too much. So that you can't just say, oh, that's not what I said. You said everything over and over and over and over again. You said it every different way you could possibly think of. So no, you're screwed. But the question is, does Tennessee have jurisdiction over Mitchell Snow in Washington State? Maybe not. That's not easy. There's a lot of tricky things involved in that, and they're very fact intensive. One would want to say, a lot of people have said this, is that nationwide jurisdiction. Let's say the New York Post says something in New York, and it's intended for nationwide publication. And I'm in Idaho. I'm trying to think of who is small, but I don't want to insult. So let's just pick Idaho. So I'm in Idaho, and it hurt my business in Idaho. And but they're in New York. They're not in Idaho. I said, yeah, but they knew that it would go. It would spread everywhere. That's pretty tricky. It has often failed. So simply to say that Mitch Snow said things on Candace Owens' broadcast might not work. It might. It might not. However, the good thing is that they can. Did BRIAN HARPOLE and the Dillon law firm, did they have to combine this all in one lawsuit? No. And there's a lot of reasons why people like to do that. They're telling one story. They want to tell a really good story. They want to tell all the details. And so there's a lot of tendency to want to put it all in one lawsuit, but it's not necessary. So if Mitch Snow, who's one of the worst actors, I think Mitch Snow will, my impression, never met the guy, but the way he's been acting, I'm going to say that. I could be wrong, but the way he's been acting is he'll just tell you anything you want to hear. It seems to me. I don't think he necessarily has an evil bone in his body that I can see. He's just like, if you ask him something, he'll tell you what you want to hear. Even if he doesn't care, even if he doesn't have anything against anybody, even if he's just a nice guy. So, but they could sue him separately in Washington State. So I know that a lot of you don't really care about some of these things, but you should. And this is going to come. This is not the last word on this. And the other lawsuits that are coming are all going to have these same features. Now, the issue is that this is in federal court. These are not federal cases. There's something called diversity jurisdiction, where the Constitution specifically allows somebody to sue in federal court if there's complete diversity between the parties, and they get a minimum of, they want to avoid hometown advantage of one of the parties. So the federal courts allow people to bring state law cases in the federal courts if they have complete diversity. To do that, you have to show that you've been injured by a minimum these days of $75,000. Not just, you were mean, but I actually lost money. of 75. You have to go, pull up the receipts and show, here's my receipt for this and this and this, and be able to show that you were injured to the extent of $75,000. This has been one of the controversies. People are saying, why are you suing for only $75,000? No, that's not what's going on. They're proving the jurisdictional minimum. That doesn't mean that they're not going to put on damages in trial more. And also the jury can impose punitive damages. The jury could say no. The jury could say, well, we're giving you $1 punitive damages. The jury could say we're going to give $10 million of punitive damages, which has nothing to do with saying that I've been injured to the tune of $75,000, or at least. That's just, you can't get in the door of the federal courts if you've not been injured at least by $75,000. That's what the $75,000 is. It does not mean they're going low. It does not mean they're lowballing. The damages are probably now, okay, for these other people. The damages are probably going to be almost entirely punitive damages. It's going to be hard, not like a big obstacle, but just life being what life is. It's just difficult to pull together the details of how do you actually lose real money. It's like you were up for a contract, and then someone lied about you, and you lost the contract. And that contract was, for $12,000. And you say, okay, what else can I put in? And you add up the damages. That's a challenge. I don't know if I would say it's difficult. It's just work. It requires more work than you think to prove that I was damaged to at least $75,000. But now I want to go to the jury and say, give me a huge damages award, or slightly different. If you don't care about your manhood and your man card, you can say emotional distress. Now, a woman, I don't want to be terribly sexist, but let's be a little bit realistic. Guys aren't going to like to say, "Oh, I suffered emotional distress. I was crying up every night." Now there are some things where you would, but when it comes to the, but anyway, so that's a species of like punitive damages. I used to go out and hike every Saturday, but all I could do was sit home and cry. Whatever the facts are, whatever the story is. So anyway, that's what they're going to do. Now, Turning Point USA is going to, because they're these days they were about an $80 million nonprofit, and they're now probably, well, one time in last year they're probably $160 million of revenue. That was a huge surge because everybody's involved in sympathy, but by averaging now, they're probably around $100 million as a baseline. Anything, if people charge too much for pencils with an organization that big, that's going to be some serious money of actual compensatory damages. And so they're not going to have any problem showing the damages, which is probably would have been better for everybody to sue together. But they didn't, and they probably won't. And it's getting a whole big crowd to row in the same direction is human nature, pretty hard. Just human nature, getting a whole bunch of attorneys to pursue one big case and not fight with each other more than they fight with the other side. It's just human nature. It's difficult. So anyway, now I think you need to know these things, and you're free to disagree by not watching. But now let's get to the big discovery. Okay, so all the candidates are saying we're now going to get the power of the court to find out all these crazy things that we have no business knowing, Um, and um, and so they're going to be able to compel everybody to confirm their fantasy that there were Egyptian airplanes, that there were honeybees that helped kill Charlie Kirk, that the French Foreign Legion was involved. Basically, if you listen to Candace Owens and all her followers, everybody killed Charlie Kirk. You can't think of any person or organization on planet Earth that wasn't somehow this week, breaking news this week. The the Macrons wanted to kill Charlie Kirk. Anybody, everybody, and somehow they're going to be able to force the court to reveal all this information, which will be the big breakthrough that the Jews killed Charlie Kirk, the Eskimos killed Charlie Kirk, the beekeepers of America killed Charlie Kirk. Everybody killed Charlie Kirk because it's a new week. We need new excitement for this week. Tune in next week for the next breakthrough. No, you can't just get discovery for any crazy thing that you want. There are rules in the federal rules of civil procedure, and they outline what you can do. You can ask for documents. The standards for documents are pretty low. Basically, discovery is it's accused of being a fishing expedition, as a metaphor, and it is. And so it's pretty loose in terms of what documents you can ask for. But there are still limits. You can ask for interrogatory, answers to interrogatories, which are just questions. The person asking for I don't know if I want. I'll just be honest broker here. But the person asking for the discovery asks 30, including subparts. So if you have 10 and lots of subparts, you may have 40 and you don't get them all answered. Now, the bad news is that Harpole sued Candace Owens LLC. They get 30. He sued Georgetown, I don't know what that is, incorporated. That hasn't been mentioned in the past. They get 30. Mitchell Snow, he gets 30. So each of the defendants gets 30 interrogatories. But that's really not that many. I mean, it goes by pretty quick. And then you have to go back to the judge and ask, well, we want more. And you can do that. You can say to the judge, this is a complex case. We'd like more than 30 interrogatories that we can ask. And the judge can say yes or no. But the judge then has to be convinced. And if you're obviously abusing the discovery process, the judge is going to say no. And now here's the biggie: protective orders. Some people are saying online, BRIAN HARPOLE is going to meet and okay, let me explain a little bit more. BRIAN HARPOLE is the plaintiff. They can ask discovery of the plaintiff. They can take his deposition. They can ask him questions, interrogatories. They can ask for documents from him. They can ask for admissions, which most people don't do. And they're very powerful, but they're very hard to write because you can't give them any wiggle room. So they have to be written very, very carefully so that nobody can squirm out of them. But requests for admissions are very powerful. But they can also go to other sources. They can issue a subpoena, but they have to ask the judge's permission. They can subpoena someone else, a bank or the Egyptian Airlines or the beekeepers. They can subpoena the Macrons. They can subpoena anybody if the judge allows it, which he won't. And I'll explain that. And they can subpoena documents from anywhere if the judge allows it, which he won't. And the reason why the judge won't is because she spent 8 months, 7, 8 months talking about all this stuff in extreme ways. So it's obvious that she's going to abuse the discovery process. The judge is going to look and say, wait a minute, why do you want this information? Because you want to sell it on your podcast and make money for yourself at other people's expense. So therefore, no, because you've admitted all over the place that the reason you want this information is to broadcast it everywhere. And that as a commercial enterprise, you're turning the court into a scam. You're turning the court into a commercial enterprise. You're using the court to fleece people. And no, we're not going to play that game. You're not going to abuse the court in that way. So unless someone comes up with a really darn good explanation for why they need this or they need that, then the judge is going to say no. Now, but here is the brick wall. Right? We say BRIAN HARPOLE meet discovery. The reality is Candace Owens meet the brick wall. The judge is going to issue a protective order. Now, I'm talking very confidently about what I know the judge is going to do because it's so obvious. Candace Owens has said she's going to use this information irresponsibly and spread it everywhere. And therefore, when BRIAN HARPOLE gets up and says, this attorney, Sean from the Dillon Law Firm, gets up and says, Your Honor, we'd like a protective order. We'd like any discovery you get to be under seal. Oh, joy. Candace Owens is going to get all this discovery she says she wants, which is probably going to prove her false, and she can't use it. If she mentions any of the discovery anywhere on her show or anywhere, she will be in contempt of court. And I know a case right now where a lawyer reported evidence of a crime to a sheriff and was accused of contempt of court under the protective order. She told law enforcement legitimately information, and she did it privately, by the way. I think the sheriff went public, but she did it quietly. And so even something you would think would be proper is dealing with essentially contempt of court, actually more serious issues. So imagine Candace Owens. Imagine that the truth actually agreed with any of her crazy ideas. And I'll say that they're crazy because everybody didn't kill Charlie Kirk. You can't go in week after week after week and allege that Charlie Kirk was assassinated by everybody on planet Earth. It's just mutually exclusive. That's self-contradictory. That doesn't make sense. And it just doesn't feel right. There's just something about this that doesn't hang together. Does that make sense to you? You know, that her whole thing is like, oh, it just feels wrong. Yeah, the idea that everybody killed Charlie Kirk, that just feels wrong. Some squirrels told me that that it's not possible for everybody to kill Charlie Kirk. So the thing is that let's suppose she found out what she thinks she's going to find out, which she won't. She won't be able to tell anybody. The judge is going to issue a protective order saying you cannot, because discovery is where you use the coercive power of the court to extract information from the other side. So you're involving the court. So the court saying we're letting you use our power to get the stuff, and therefore there are limits on that power. Now, if you already know it, if it's your own documents, if you can find the documents some other way, then you can do whatever you would normally with them. But if you're going to use the court to pull information out of somebody, then the court is going to put limits on it. Say, okay, we can only use it for the purpose of this lawsuit. And if you get to the point you're actually going to disclose it in the courtroom, you have to ask them. The judge has to say this is what it really means. So, um, so she's not going to be able to talk about it until maybe as it gets, possibly at the trial. But that's not what she's looking for. She's looking for a scandal industry. So anyway, the discovery is, but also if the discovery is not relevant, the judge will say no. Now, I've often said when I was a practicing lawyer that you don't know what the judge is going to do. Everybody has their ideas about what judges like, what judges don't like, but here it's just so egregious that a judge would not overlook it, and a judge would not want to be publicly criticized for missing such obvious things. But so the thing is that so Candace asks. The thing is, in this lawsuit, BRIAN HARPOLE has chronicled what Candace Owens said, and then why it's wrong, why it's false, and there was no justification for saying it. That's done right. People are wondering why is Turning Point taking so long? Because every day there's new stuff. Some associate lawyers are writing down all the stuff that Candace Owens is saying every single day, and the pile is getting higher and higher and higher. And a good defamation lawsuit, I was going to say, most lawyers do not know how to do defamation cases, to bring them or defend them, because it just doesn't come up that often. And I've been forced, working for Larry Klayman at Judicial Watch and then Freedom Watch and other places, to spend a lot of time on defamation cases, not because I'm so great, but I just got thrown into that pool and ended up doing a lot of it. A good defamation lawyer can bring a good defamation lawsuit and almost certainly win if the facts are there. If it's what happened. A bad one will take a clear winner and lose it. And the same on the defense side. They don't know really what most people, it's just not part of their bread and butter to deal with defamation cases. And therefore nobody wants to touch it, and therefore it becomes a self-fulfilling prophecy. So it has to be done correctly, and doing it the way Dillon law firm did, it is the correct way. They took, they listed everything she said, and then listed why it's false. And that's why this is so big. That's why I'm sure Turning Point USA's work in progress is probably this big. And that's what has to happen. Now, there are some lawsuits that are really routine, but in most lawsuits, in terms of workload, not in terms of seriousness, but it's like putting on a Broadway play on opening night. I'm not trying to denigrate the importance of the issues in the law. I'm just saying that every piece of the case has to come together at the right point, at the right time. You have to have your documents. You have to say, okay, here are 5 or 10 copies of the evidence. I'm giving it to the witness. All these pieces have to all come together at the same time. Everyone has to know their mark on the floor, the mark being where the actor is supposed to stand. The workload in bringing it together is a performance. It's a serious performance, but it's still like if you don't bring it forward, if you don't present it well, you can lose an unlosable case. And so a lot is going to depend upon lawyers. Do they, who puts on the better performance? Who presents the case better? So could BRIAN HARPOLE and other people lose? It's possible. If the lawyers do not, you leave the crucial piece of evidence at home and you don't have it. I mean, that sounds so silly, but every little pesky detail has to come together in perfect form. And so a lot will depend on the lawyers. In many cases, they don't, because it's just the law is the law. It's so obvious, it's so routine. But in something like this, you have to bring all together just right, in order to win at trial. Um, so I was going to say something else. Um, I'm not going to say one thing. I'm not going to say one thing that could help them. But it's not. It's still. It's not going to be. It's not going to be hidden. It's going to become obvious. Um, oh, the scope of discovery. About that was what I was just about to say before. The a motion to quash. Now the way, and see, this is bad because fair or unfair, um, Candace Owens has approached these issues in such a way that BRIAN HARPOLE and other people who sue say, look, this is how she goes about it. She's going to do it in this case too. That might be a cheap shot. I've had cheap shots against me. I've had, other, I've seen it, but it's going to happen, whether it's a cheap shot, whether it's fair or not, and say, look, she's going to grandstand and be like um, a tabloid, because here it is. I can show you on her show, and so if she just asks about things because she wants to know, then BRIAN HARPOLE or in the other companion cases that I'm sure are coming, the plaintiffs can say, no, that's not part of this case. You can't just, go roaming across the land. Discovery does not mean whatever the hell you want to think about. You have to show why does it matter in this case, why it is more useful than harassment. Whether the judge is entitled to weigh it. So I said earlier that the requesting party for discovery, they get 30 interrogatories, including subparts, but not if the judge says no. So, as I said, you go through all the different times that Candace Owens has said specific things, which I'm sure she thinks she was clever, but she was not, because she said the same things too many different ways. And so she may have think that she, dodged a bullet, but she didn't. The jury is going to accept it. Even the judge on a motion to dismiss is going to give the benefit of the doubt to the plaintiff, and it's going to be difficult. But she said all these different things, and any discovery about the allegations are fair game. So if she said something about BRIAN HARPOLE or the other companion lawsuits that I expect, Turning Point USA, whatever, that's fair game for discovery. And the judge might very well enlarge the quantity above 30 interrogatories and allow lots of discovery, lots of documents. The amount of requested documents is going to be very large, and it could be a very expensive fight about that. But so the judge could, each of the issues that were mentioned on the show, or the information that is false. Why it's false? Why she had no basis for saying it? Those are all fair game. Those are all issues that the jury is going to have to decide. The jury is going to have to see the evidence and make up their mind. Therefore, the parties are entitled to obtain whatever information might exist that would help in determining what is true, what is the case about truth, but what is accurate or inaccurate in the case. So the jury can decide, the jury can be exposed to the evidence and the documents. So any issue that is brought up is going to be fair game for discovery, and there are a lot of them. So that's a downside. BRIAN HARPOLE and I'm sure the other plaintiffs will be very comprehensive. Like, this is undeniable, but that means every one of these issues can be put into discovery, and so that's a hell of a lot of discovery. However, Candace Owens cannot just go randomly talk about everything under the sun. Um, it has to relate to an issue in the case. It has to relate to something that would help the jury decide one way or another. So if the other side says no, I'm filing a motion to quash. This has nothing to do with his case. This is just random curiosity, or maybe it does have something to do with his case, but it is more harassing, more burdensome than justified. Like there might be a tiny value in the case, but the other interests, personal issues, harassment, just the sheer burden of trying to come up with all these documents. The judge could say, no, I'm not going to allow you to do that, or modify it and say, well, I'll let you do it for these years, or I'll reword your discovery request to balance all of these issues. So the judge, even the standard discovery issues, the judge can supervise whether one of the parties is out of control. We haven't seen a history of it, but there are plaintiffs who could ask things about Candace Owens that would be cheap shots, would be in the court of public opinion, might be relevant, but really not in a court of law. So it goes both ways, but one, Candace Owens has shown an inclination towards it. So I think that's what more than maybe, I think that's what you need to know as you watch this go forward. And again, this is going to affect more just if you follow Candace Owens or the Supreme Court USA. This is designed to slander and smear and affect the entire election and the electorate and make everybody just have a queasy feeling in their stomach on election day. But this is what you need to know, maybe more than you wanted to know. But these are the things that I think are of immediate value right now. We'll have a lot of developments going on with this and others. I'm thinking you might be prepared just with this one session alone to follow what's going to happen. It's going to come along, but I'll pop on if there's something that we see happening. So thank you very much. It's John Mosley again, former lawyer, 26 years. Enjoying the weather down south now, and I just want to leave you with the thought that thinking is good. Want there to be more thinking in this country because thinking is important and thinking is a good thing. Thank you very much. Have a wonderful day.